Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Min Kim from our Edison, New Jersey office. Hi there, Min, and welcome.
Hey Ariana, thank you for having me back.
Thank you so much for being here. For today's topic, we will be talking about preparing for USCIS FDNS site visits and sharing key insights for employers. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please comment them below or email us anytime at info@chug.com. Let's get into it, man. So, with President Trump retaking the White House, there's been an uptick, to put it mildly, in immigration enforcement and compliance. It seems like there's a new headline every day in the news of ICE agents conducting raids, immigrants being detained or flat out deported, and non citizens being denied re entry to the US. So for today's Thursday Live, we want to further explore such enforcement proceedings, but from the standpoint of a U.S. company which employs foreign nationals on work visas.
Right, that's absolutely right, Ariana. I suppose when most folks think about immigration enforcement and compliance, they immediately think about illegal immigration or folks who perhaps enter the U.S. without inspection. But immigration enforcement and visits from government officials, it can and often they do extend to legal and lawful immigration as well. And with the implementation of the H-1B Modernization Rule that speaks to FDNS site visits and how that new rule expands the scope of such visits, hopefully today's time will help employers better prepare themselves if they happen to be on the receiving end of one of those unannounced site visits from FDNS.
Exactly. And once again, FDNS is short for Fraud Detection and National Security, correct?
Yeah, it is. It's part of USCIS. The agency FDNS. It began in 2009, and mainly the FDNS unit. It consists of USCIS officers who are tasked with verifying the terms and conditions of an underlying non-immigrant petition filed by an employer on behalf of a foreign worker.
Non-immigrant petition, do you mean Form I-129?
That's right. As part of the employer representative, signing off on Form I-129, if you read carefully the instructional heading right above the signature block, it reads on page 6, and I quote, the employer, obviously the employer representative, also recognize that any supporting evidence submitted in support of this petition may be verified by USCIS through any means determined appropriate by USCIS, including but not limited to on-site compliance reviews. Now, on-site compliance reviews, that's what a site visit is. And the employer, when the employer signs, it thus agrees to such on-site compliance reviews when these I-129 cases are filed with USCIS.
But just to be clear, though, not all visa classifications are subject, are they? Isn't there a limited number of visa classifications which are subject to site visits?
Yes and no. The Trump administration, they can look to expand the reach of such site visits to most, if not all, visa categories. But in practice, the government doesn't really do this. We're mainly talking about H-1B visas for specialty occupation workers, L-1 visas for intercompany transferees, and R-1s for religious workers. The FDNS site visit directorate is typically limited to ensuring compliance for these three types of foreign national employees.
Gotcha. So it appears pretty clear to me that employers really have no choice. They need to comply and cooperate with an FDNS officer if such a site visit is scheduled. I mean, the employer signs the I-129 form consenting to such cooperation, right? Whether the employer reads that instructional note or not, they sign, so they agree to the program.
In the far majority of circumstances, yes, I would agree with you there, and employers should cooperate. But it begs the question, must an H-1B or L-1 employer always cooperate with an FDNS site visit? Not always. The employer technically can say no. but I would strongly recommend against it. As you correctly point out, the employer knowingly or unwittingly agreed to such on-site compliance reviews when it signed the I-129 form and filed a visa petition for its employee. By doing so, it agreed to not just open the doors of its facility and workspace for an FDNS officer to enter and investigate, but also agreed to grant access to other work areas, which might be fair game for an FDNS officer to visit and poke around.
Yes, we will definitely get to that as part of today's time. How far is the reach of a site visit? Where can an FDNS officer go, and what can an officer ask for? But before we do, in order to help our audience prepare for such unannounced site visits, can you give us a quick rundown of what an FDNS site visit might consist of and how the new H-1B modernization rule might have expanded the program?
Yeah, absolutely. When an FDNS officer appears at an employer's office space, the officer will likely ask to speak with the company's HR manager, or maybe the person at the company who signed the I-129 H-1B or L-1 petition. If that person who signed is absent, or maybe let's say working off-site that day, that information should definitely be shared with the officer, and the company can try to reach that person over the phone. Another alternative is that if the company used a law firm, perhaps, in helping to file the I-129 petition, the company can ask the officer if they can contact the law firm and have the attorney representative on the phone to help answer whatever questions might be related to the site visit.
If I can stop you there, Min, what about asking the officer if he or she can possibly reschedule and come back later? It would appear to me that the company representative, whether it be HR manager or the owner of the company who signed off on the I-129 paperwork, that person is sort of essential to be there to receive the FDNS officer. Can the visit be rescheduled?
Not likely. Although the new H-1B modernization rule does permit such rescheduling, and I suppose it doesn't hurt to ask. But in reality, the FDNS officer is probably busy with other administrative site visits that he or she needs to complete, and the officer selected that day to visit your company, so the site visit will likely take place that day. But even if it cannot be rescheduled, the opportunity to have the HR manager or attorney on the phone, that should be available. And the officer should understand that having that person on the phone can only help speed up the site visit.
Fair enough. Let's talk about those things that need verification. What can employers expect?
The officer's main responsibility is to first verify, the existence of that employer, and in general, the validity of the information provided on the I-129 petition form, and whether the foreign national is in fact working in compliance with the terms of the H-1B or L-1 approval. The officer can choose to take photographs of the facility to verify its existence and interview the foreign national worker. The officer might request interviewing the foreign worker supervisor or other related personnel, to confirm the details of the work area, as well as seek information that confirms the foreign national's working hours, his or her salary, and specific job duties. In general, site visits, they typically take less than 1 hour to complete. And at times, if things go really well, the site visit can be wrapped up in around 15 to 20 minutes.
Well, that's certainly good news. I'm sure the officer has other things to do and other employers to visit as well, but 15 to 20 minutes is pretty short.
It is. But keep in mind that it only gets that short if an employer is properly trained and knows what to expect. If an employer has a policy in place and a blueprint to follow, let's say, to give the officer what he or she is asking for without delay, and there's no, hemming or hawing, or we need to pull up something from a different location because it was not maintained properly in one space, then the officer has everything that they need to confirm the terms and conditions of H-1B or L-1 employment. They were able to speak to the foreign national beneficiary. They were able to speak with other workers and verify everything they needed to. The workspace was at the location as specified on the I-129 form. It was sufficiently lived in, meaning that the beneficiary's belongings were there, and it was clear. It was clear that the space belonged to the beneficiary. Payroll records, supervisors had to say what they had. whatever they have to say about the beneficiary's work, all that sort of checks out. And if it does check out, then 15 to 20 minutes is all FDNS needs. Now, if one of those things don't check out and either are in conflict with something else that was discovered on that day or perhaps in contradiction to what was included on the I-129 petition form, then that's when the visits can get lengthy and burdensome.
I hear you, and I'm sure our audience does as well. There's enough anxiety in seeing a government officer knock on your door and wanting to take pictures and interview people and go through employee files. So, in order to get in front of all of that and reduce the burden, it's so critical for employers to have a robust and written up policy on what they will do in the event of such a visit from FDNS. So, okay, with those basics in place, let's transition to the H-1B Modernization Rule. I know we went into the finer aspects of that rule in January and how it changes the FDNS site visit program, but please provide us with a refresher. And as a quick reminder for our audience, if you are curious about that Thursday live, please check it out on our YouTube and LinkedIn pages.
Yeah, of course. The H-1B modernization rule, it essentially codified, or I suppose that's just a fancy way of saying, made it official as a rule of law, the FDNS site visit program. And it made it clear that refusal to cooperate on the part of the employer may mean grounds for visa petition being denied or revoked. It also expanded the scope of the program to allow FDNS officers to visit foreign workers' homes or third-party and client sites if the beneficiary will be working at those locations. It also made clear that there is no hard cap to the type of information that an officer might seek, so long as that piece of document that is requested is pertinent to the investigation. Now, what does pertinent mean in practical terms? I suppose that's up for debate, but it does provide some guidance in that an FDNS site visit should never be an open license for the officer to go on a fishing expedition and ask for any and all things related to the company and its business. Anything that might be directly related to what was included as part of the original I-129 petition, all that is fair game. And perhaps some things that might be a bit removed even from the I-129, but the further you get away from the petition and the more attenuated and non-relevant the document might be, I think it's reasonable to think that such documents would not have to be released on the part of the employer. Or at the very least, a follow-up question can be asked of the officer to perhaps explain the reasoning for requesting the document and asking for some time on the part of the employer to produce it.
That's fair. And strategically, I'm sure that just asking for more time might help the situation overall because it allows the employer to perhaps circle back with their attorney, ask for advice on how to respond, and whether that piece of information is really pertinent to the site visit.
Precisely.
Okay, Min, if there's one thing about government I know, it's that they follow a specific blueprint, a standard operating procedure of sorts. I would imagine that something similar is followed here for the FDNS site visits. Can you share with us some insights on the types of questions or requests for documents that an FDNS officer might ask an employer representative or a foreign worker in one of these site visits?
Yes, of course. You are correct that most times the FDNS officer usually works from a standard list of questions. Some relevant questions that I gathered that employers should be prepared for are what types of products or services are offered by your business? How many total employees do you have? Are they full-time or do you also have part-time employees? What's the total number of H-1B employees that you employ? How many total H-1B petitions have you filed as a company? How many employees are working on-site at this facility? And how many are off-site working at remote locations? What's the total number of clients your company has for which your H-1B employees are working for? Did your company let any employees go recently? How many employees were laid off? What was the reason for this corporate downsizing? How many hours per week does this H-1B beneficiary work for you? What's his job title? What's their annual gross salary? How often are your employees paid? Are they paid every 2 weeks, every month, weekly? What's the typical work schedule look like? Provide all addresses where the beneficiary works. What is the company's total number of employees at the beneficiary's work site? Who paid the USCIS filing fee costs for that I-129 petition? When did the beneficiary start working for your company? Give me a specific description of his job duties. Who is the the beneficiary's direct supervisor. Is he or she here? Can I speak with them? If the beneficiary is removed and working at another company's facility, who is the on-site supervisor for him? Do you provide on-site, off-site supervision? How is that supervision administered? How long has the supervisor been with your company? How many other employees does the supervisor supervise?
Okay, let me stop you there, Min. First of all, that's quite the list. It does appear that almost anything and everything that is even somewhat related to the I-129 petition is fair game to be asked. But for some of these questions, like how many total H-1B petitions have you filed as a company? What is the total number of clients your company has for which your H-1B employees are working? How is one HR manager supposed to know all of this? Isn't that a little too much for the officer to be asking?
Yeah, it's a fair point, Ariana, and I agree with you. And just going back to the questions, I mean, it's an exhaustive list. I don't fully expect any officer to be asking all these questions all at once in one site visit. But I suppose just historically speaking, it seems like these are the type of questions that an officer would kind of fall back on in kind of knowing what historically the site visit is intended to capture. But no matter how prepared an employer might be for an FDNS site visit, because the investigation of the site visit is pretty vast, no HR manager or employer representative is going to know every answer to every question during the course of that site visit. That's why I think it's entirely fair and appropriate for an employer to ask the officer for more time. Things like the number of all sponsored foreign workers employed by the company or the number of immigration petitions filed by that employer within a certain given period of time. That's going to take some time to retrieve. So if the company representative needs some more time to attain that data or seek out their immigration attorney for help, they should let the officer know. Most times the officer will likely accommodate.
Okay. Any other tidbits? I'm sure you have other examples of questions that may be asked.
I do. It's pretty much assured that the officer will also want to interview the employee who is at issue. Some of the questions that are commonly asked of the employee and which the employee should be prepared for. I have a list here. What's your job title? What's your annual gross salary? How often do you get paid? Biweekly, monthly, every week? What's your work schedule like? How many hours per week? And at what address do you normally perform your work? How long have you worked for this company? Do you supervise anyone? Are you doing the job you were initially hired to do? How many positions like yours are there at this company? When was the last time a performance evaluation was done for you? Have you received any performance bonuses or raises? Who paid for this I-129 petition that was filed for you? Did you happen to reimburse the employer at all? What is your highest educational degree earned? And where did you attend college? If the foreign national happened to have a previous history as an F1 student, a question might be, did you work under the OPT program while you were an F1 student before you became an H-1B employee? And if so, what companies did you work for? And how long did you work for those companies? Describe your overall employment path with this employer. When did you start? What visa status did you have? And when you started? And when were you ever promoted? And lastly, do you have family here in the U.S.? Does your spouse happen to work?
Wow, those are some rather general questions. And I guess one thing I noticed is there is some overlap between the questions asked of the employer and the questions asked to the employee. I assume that's the case to try to find some inconsistencies in the responses. Am I correct?
Right, that's correct. I suppose that is the reason, and the compelling reason I suppose to consider is to try to have the employee decline any one-on-one interview with the officer because of that. But instead of that one-on-one interview, have the employee always be accompanied by the employer representative or the G28 attorney, so that any perceived inconsistencies can be ironed out right then and there, or perhaps addressed later at a later point in the event that an adverse decision happens to be received.
You mentioned before that the H-1B or L-1 employee's supervisor might also be interviewed. What are some questions that the supervisor might receive?
A supervisor, I suppose, may be asked to further describe what his or her specific department does for the company. I suppose some other questions that the supervisor may receive are, let's say, how many other employees within your department share the same job title and responsibilities as the beneficiary? Can I speak with them? Are they all located here at this facility or are they remote? Amongst your team members, how many are US workers? How many are here on work visas? Is your department appropriately staffed? How do you go about evaluating the performance of your employees, including this beneficiary? Also some questions that the supervisor or HR manager might receive, which are specific for L1 employees, because you have to bear in mind, we're not just talking about H-1B employees who are subject to site visits, but also the L1 visa program is also subject. How long has your beneficiary been employed overseas before he joined your company in the US? What was his job title at the overseas employer? Was the beneficiary's job overseas, was it primarily executive, managerial, or did it involve specialized knowledge or something else? How many employees did the beneficiary manage as part of their overseas employment? Does the beneficiary manage people or process here in the US job? And if the beneficiary happens to manage a function, describe that function and provide names, contact information, job duties, salary of the beneficiary subordinates, along with copies of their pay stubs.
It's remarkable the wide range and breadths of the types of questions that can be asked during these site visits. Min, I know you said that these aren't intended to be fishing expeditions, but I don't know. I'm just not convinced. But regardless, the information shared is invaluable as our audience today can perhaps have a more informed understanding of what these FDNS site visits consist of, especially as Trump continues to make enforcement and compliance priority issues in today's immigration climate. So we do have a bit of extra time here today, and I can see that some questions have been received. So would it be okay if you stuck around and answered some audience questions?
Yeah, absolutely.
Great. So the first question, if an FDNS site visit happened at my company and the FDNS officer was satisfied with everything and there were no findings of contradictory information, can we safely assume that there won't be any future site visits since the first one went okay?
Um, I would think not, unfortunately, especially if your company employs many foreign workers on H-1B or L1 visa status, because each one of those employees I-129 petition, it's a standalone case from USCIS's standpoint. So just because the first FTNS site visit went okay, it doesn't mean that future visits won't be on the horizon. If the government happened to receive a tip, let's say, from someone to initiate another investigation, or perhaps your company just got caught up in the randomized queue of USCIS deciding which petition to conduct a site visit next, just because that company had one before and it went well, it doesn't exempt you from a future one.
Thanks for answering that. We have a second question. What happens after the site visit if the visit occurs and we don't hear anything at all from USCIS post-visit? Does that mean we were deemed compliant and USCIS does not require anything further? Should we try reaching out to USCIS to inquire into the status of the visit?
When it comes to the universe of FDNS site visits, I suppose the golden rule for me is that not hearing back from the government is generally a good thing. A site visit, it often occurs to verify the terms and conditions of employment as specified earlier by that petitioning employer. So, if post-visit, if no communication is received from USCIS, then I suppose you can safely, assume that the government was satisfied with the checks that it performed, and everything which needed to be verified was verified as part of that site visit. So yeah, there wouldn't be any need to reach out to USCIS and inquire anything further.
Okay, looks like we have time for one more question. As an employer, can we deny an FDNS officer's request to interview an H-1B employee alone and in a separate location off-site and away from our company property? Does it change anything if the employee asks the officer for the employee representative to also be in attendance? Is that request ignored and the officer can just demand that he speaks with the employee alone?
That's a good question, and I suppose it kind of circles me back to the H-1B Modernization Rule and the history regarding that rulemaking. The rule, it does state that if an H-1B employee requests that his employer representative or immigration attorney be in attendance, either in person or perhaps over the phone, the FDNS officer should not deny that request. So I suppose essentially the officer cannot unilaterally impose a one-on-one interview with just the employee. So at least in the H-1B context, it seems like the rule supports the notion that as long as the H-1B employee requests to the FDNS officer that they are accompanied by their employer or attorney, such a request should be honored and a one-on-one interview avoided. At least that's what the rule says, but who knows whether that actually happens in practice.
We hope it does, Min. We definitely hope that it does. I can't think of a more nerve-wracking situation than a non-citizen being escorted by an FDNS officer to an off-site location so that a one-on-one interview can be conducted without the representation and oversight of either an employee representative or the attorney involved. But that is all the time we have today. Thank you to our audience for tuning in and sending in your questions. This brings us to the end of our conversation. A special thank you to you, Min, for taking the time to answer our questions. To stay up to date, please subscribe on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, send us an email anytime at info@chook.com. Let us know what topic you want to see next. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you everyone for tuning in. Thank you again, Min.
Thanks, Ariana.